Greetings and hello to all of you social distancers out there who are joining us as we continue to make our way through an examination of America's three fundamental founding documents, the Declaration of Independence, the Constitution, and today our focus is going to be on the last of the three, the Bill of Rights. Remember that all three of these documents were written, published, and put into force during just a 15-year period, a very fundamentally critical 15-year period in American history between 1776 and the ratification of the Bill of Rights in 1791. As we alluded to earlier, we recognize the Declaration of Independence to represent, for our purposes in examining these documents, the foundation, the place within which many of the primary fundamental principles that would later make their way into the Constitution and the Bill of Rights were first fleshed out and were first articulated. We recognize, as we've looked in our past two lectures, that many of the points in the Declaration of Independence, many of those grievances regarding the misgovernance of the colonies by the British king, had to do with the fact that colonial residents were being denied self-government, were being denied the opportunity, which many of them had previously enjoyed to some degree, to elect colonial legislatures who were then able to do things like make laws and levy and collect taxes on behalf of all of the colonists. And we recognize, of course, how the Constitution created a representative system of government. It created a process whereby citizens could exercise the power that they collectively held in a democratic process, electing those who would make important decisions on their behalf. Now, beyond this, we remember the Constitution, in setting limits and defining the powers of the various elected branches of our national government, our federal government, the powers of Congress, and the powers of the President, the Constitution would act to help create for the United States a republican form of government, where the will of the majority, as expressed in elections, could be tempered and controlled by the dictates of the Constitution. And secondly, because the Constitution created a federal system of government. We remember, of course, that the Constitution, representing the 13 states initially, collectively giving to the national government, the federal government, a certain delineated number of rights, duties, and powers, which in theory had originally been the province of the states, so that the federal government, the national government, could act as one government on behalf of all the states, but recognize that all the rights that had not been specifically given to the federal government were going to remain within the province of the individual states and their legislatures. A democratic elective process putting into power a republican system of governing, where again, elected national bodies, Congress and the President, were limited into what they could do by virtue of having won a majority of votes by the firm rules set out in the Constitution, and then further checked by the limited nature of its powers and the powers that remained in the hands of the individual states. A very important principle that I think bears repeating at the outset of this presentation. Now, we hear, of course, of excerpts from our founding documents. We hold these truths to be self-evident. All men are created equal. Great propositions regarding the right to vote. And we recognize now, 230 to 240 years later, that many of the propositions first set out in these founding documents were aspirational. Maybe they were goals, because we recognize that as a nation, it would take a very long time until the equality of all, the universal right to vote, would be many decades in the making, sometimes as a result of war, sometimes as a result of great social uprisings, to make the United States today a country that can be said lives more completely by those aspirational assertions made when these documents were written. We would see over time a universe of voters and office holders limited to just white men who owned property, to more broadly by the 1820s include all white males, irrespective of property ownership. Following the Civil War, following the post-Civil War amending to the Constitution, the 15th Amendment would, in theory, guarantee to all men, white and men who were African American, former slaves, and their descendants, the universal right to vote. And it wouldn't be until just 100 years ago, in 1920, when the 19th Amendment to the Constitution was ratified, delivering to all women in the United States the universal right to vote and implicitly to seek and hold elective office in America. So a long process of an evolving and expansion of these constitutionally asserted and guaranteed rights. Now, when we last met, the Constitution in in September of 1787 had been completed. Its writing done by 55 delegates taking part in a constitutional convention. It was signed and then sent off to the states to begin a process where the Constitution required 9 states would have to ratify the Constitution before it would become the law of the land upon all of the states. 9 out of 13, a high bar that had to be met. And almost immediately, as the ratification argument began to take place in state legislature after state legislature, 2 significant factions emerged. One favoring ratification, the unimaginatively named Federalists, and those opposing ratification, the equally unimaginatively named Anti-Federalists. And we would see both nationally, through the printing of pamphlets, through the printing of articles, through the publication, for instance, of a number of anonymous writings at the time called the Federalist Papers, authored primarily by James Madison of Virginia and Alexander Hamilton and John Jay of New York State. The Federalist Papers were not neutral treatises on what the Constitution meant to do. They were fiercely pro-ratification documents. On the other hand, we would see men like Patrick Henry and Richard Henry Lee of Virginia begin to circulate what came to be known as the Anti-Federalist Papers. Again, explaining reasons why delegates in states, when the time came to vote, should not vote to ratify that Constitution. Now, the bulk of the arguments against ratification could be broken up into 2 broad categories. To some respect, challenges and perceived problems in our constitutional order that we still hear mentioned from time to time at the present time. One had to do with, again, that mysterious national government, that abstraction, that federal government, which at the time was nothing more than ink printed on parchment, that reading it seemed to create an awfully powerful new and potentially superseding government. over those of the individual states. This entity called Congress, this House of Representatives, this Senate, this president, who seemed to have an awful lot of powers that he alone would wield, and of course the Supreme Court and other federal courts that Congress might choose to create. The argument was simple. In creating so many powers and in giving to this national government so many powers, each of the individual states were putting themselves and their citizens in jeopardy. Jeopardy to the unknown whims of federal office holders, and the belief at the time that the national government, the federal government, was one where in fact a few leaders might be able to take power and thus deny to Americans this representative form of government and permit these federal office holders to effectuate, again, an American-made tyranny by virtue of the Constitution on America's citizenry. A very powerful and a very potent argument at the time. You think about the argument as it's framed today. You read the newspapers and look at the news regarding the battles involving the president and various governors and citizens of the states regarding how much social distancing should be engaged in and who has the right to determine, is this a national question or an individual state question? And we see that in the battle to ratify the Constitution, the states' rights argument was already being made at the time in a different way. Now, secondly, the objections to ratifying the Constitution in, again, late 1787 and 1788 had to do with the fact that a whole number of those earlier grievances, first articulated in the Declaration of Independence, were not addressed in the body of the Constitution itself. Because we recall that in these grievances, 2/3 of the Declaration of Independence, in fact, is a laundry list of these grievances. A large number of them dealt specifically with actions of the British government denying citizens of their colonies individual rights, liberties, and freedoms. Some rights which had already been guaranteed to British citizens by virtue of the English Bill of Rights that had been adopted in 1730, but more broadly, rights that could be described as universal rights, inalienable rights, those rights that the Declaration asserted were so personal, no government should be able to intrude upon them. So the grievances talk about the denial of the freedom of speech and freedom of assembly, the persecution and prevention of the operation of a free press and those able to write about the actions of the British government, the housing of troops in people's homes without their consent, the illegal, warrantless, groundless searches that were being conducted by the British Army in the homes and in the personal effects of those they suspected of being colonial subversives. The facts that oftentimes property was taken arbitrarily by the British without compensation to those in the colonies from whom they were taken, and the fact that oftentimes confessions were extracted from individuals using means that would constitute coercion of various types. The grievances speak to the fact that individuals arrested and charged with crimes were not given a speedy trial, a public trial, the right to counsel, nor the right to confront witnesses. We would read of assertions in the grievances of colonial residents being subjected to cruel and unusual punishment when they were detained by the British. So the question the Anti-Federalists ask in legislature after legislature after legislature a very legitimate question we're going to see is that where in the four corners of this proposed Constitution itself does it say that this newly created national government, this federal government, cannot do what the Declaration of Independence accused the British government of doing, and that is infringe, intrude, and deny to American citizens these important, fundamental, universal rights. Now, that second argument, that latter argument, was in fact a very powerful one. It would cause, as the last few states began slowly moving towards ratification, the proponents of ratification, the Federalists, to basically assert to colonial representatives who had the task of voting to ratify, basically making the following statement. We hear you, because in fact there are no limitations placed on the federal government regarding these individual rights, but many delegates were directed to Article 5 of this Constitution, which had a method for amending it. And the argument went that, number one, trust us and ratify the Constitution first, and then, following the election and the gathering of the very first Congress, that Congress, pursuant to Article 5 of the Constitution, can begin a process of drafting and approving proposed amendments that would then be sent to the states for their consideration. In a much more trusting time, in a much more sober time, perhaps, these assertions did in fact cause sufficient states to vote to ratify. In June, in fact, of 1788, New Hampshire would become the all-important ninth state to vote to ratify the Constitution, and the clock would soon begin ticking for the holding of the first congressional elections, and in a process created in the Constitution, the first process, the first election to elect that President of the United States. Something that we'll talk about, this electoral college system, much, much more as we make our way deeper in the year towards Election Day on November the 3rd. So soon enough, states began electing their members of Congress, citizens coming from their districts to elect their member in the House of Representatives, state legislatures, remember, selecting the two senators that would represent each state in the United States Senate. March 4th, 1789, the very first Congress would meet in New York City. Among the things it would do would be to ratify the results of the electors in the 13 states that had unanimously elected George Washington to be the first president of the United States. In 1792, Washington would again be reelected unanimously, winning every electoral vote, he being the only president in American history to accomplish that feat, a unanimous win among electoral votes cast. And on April 30th of 1789, George Washington would take the oath of office at Federal Hall in New York City, the then provisional temporary capital of the United States. Now, Article 5 of the Constitution contains the process whereby that document could be amended. It actually offers two ways. but only one of them have been utilized in what have now been 27 amendments made to, again, that initial United States Constitution. The method involves two steps. Today, think about these steps in our current politically polarized environment. Citizens are more polarized, and therefore those who represent us in Congress are more polarized. Or is it the other way around? Are members of Congress more polarized, thus causing citizens to be the same? So the first step, which used to be the easy step, is that any proposed amendment would first have to be ratified or approved by a 2/3 vote of each House of Congress. Today, 67 senators, about 285 members of the House would have to vote to approve a proposed constitutional amendment. If this first step is achieved, that amendment is then presented to the states. Note that the president, and the courts for that matter, do not play a role in the process of amending the Constitution. That proposed amendment is then sent to the states, along usually with a time frame, sometimes 3 years, sometimes 5 years, as long as 10 years, where within that time, 3/4 of state legislatures must vote to ratify that amendment. Today, that would require 38 out of 50 state legislatures voting to approve that amendment. At the moment the 38th state casts a ratification vote, that amendment immediately becomes part of the Constitution. So in 1789, the very first Congress went to work in drafting proposed amendments to the Constitution, and by later in 1789, 12 amendments would muster sufficient votes, 2/3 in the House, 2/3 in that Senate, to make the next step to go to the states for their legislatures to consider. The first two amendments were, for lack of a better description, sort of housekeeping amendments, trying to clarify and perhaps explain away ambiguities in the Constitution as written. The first proposed amendment would have required that as America's population grew, the size of the House of Representatives would automatically have to grow, so that there would be guaranteed for every 50,000 Americans, one representative looking out for their interests in the House of Representatives. Had that amendment been ratified, by the way, it's thought that the size of the House of Representatives, by the point that we exist in America today with 330 million people, would be about 4,500 House members. That amendment, of course, was not ratified, not then, not ever. The second proposed amendment was one that stated, think about the cynicism already being felt perhaps at the time, stated that members of Congress could not vote to raise their own salaries to take effect within the current Congress that they are meeting in. You could vote to raise the salary of Congress at some future time, but not in the course of the current Congress that was meeting. That amendment at the time was not ratified. It was cast aside, but lo and behold, almost 200 years later, in 1992, that amendment, resubmitted to the states, was ratified, becoming the 27th Amendment, the last time the states have undertaken the task of amending the Constitution. The next 10 proposed amendments were those that were directed again towards addressing the concerns regarding the protection of rights, liberties, and freedoms. And the 10th Amendment, once again, underlining the fact that the national government, the federal government, was going to be a government of limited powers, while those that were not specifically given to the federal government, nor denied to the states, were going to belong, in case anybody didn't understand in the Constitution itself, those rights were going to belong to the states and to the citizens of the states. So the ratification process would carry over through 1790 into 1791, and finally, late that year, sufficient numbers of states having voted to ratify them, those 10 amendments would become part of the Constitution. The first 10 amendments to the Constitution, the Bill of Rights. Now, to think about it, again, this process for amending the Constitution, something scholars believe the founders and the framers wanted to be a difficult process to do, has led to the document only being amended 17 more times following the ratification of the first 10, the Bill of Rights. The framers believed that they had gotten the proper balances correctly at the federal level, the balance between the federal government and the state governments, and did not want to make their work, the Constitution, something that could be easily altered in the future. Many of us live in states, I happen to live in Florida, as do many of you, where our state constitution is so easily amended. And every time we hold a national election, every even-numbered year, you could bet your bottom dollar that Floridians are going to be asked in one way or another to amend our Constitution, usually to add some additional right or some additional recognition to this already overburdened document. Floridians have shown a desire to ratify just about any proposed amendment you put in front of them. Not so for our federal Constitution. So we recognize 3 post-war civil rights amendments, the 13th, 14th, and 15th, were necessary, as we're going to talk about in a bit, to help create citizenship rights and all the rights attenuated to a citizenship to individuals who previously had been African slaves and later, of course, their descendants. We recognize that 2 amendments dealt with booze. The 18th Amendment brought about prohibition. It was ratified in 1918, and then 15 years later in 1933, the 21st Amendment repealed the 18th Amendment. Alcohol could once again be manufactured and sold in the United States. But again, these first 10 are so critical that they are considered to be, again, a founding document, one of the 3 essential ones that makes the United States still today, in many ways, different from other democratic systems around the world, the fact that we have an articulated Bill of Rights. Now, as they were ratified, and really until 1925, the Bill of Rights were limited to restricting actions taken only by the federal government or departments and divisions of the federal government. Put another way, until 1925, individuals could not go to a federal court to ask a federal judge to prevent the state within which they lived, or their county, or their city, of engaging in action that violated constitutionally protected rights. States could violate or not provide these important constitutional guarantees until the Supreme Court began a process in 1925 that would extend the protection of most of the fundamental rights created in the Bill of Rights to protect citizens from actions by their state government, their local governments, state police, sheriff's departments, city police, in a way that prior to this period did not protect state citizens. So the Bill of Rights begins, and again at a time when conciseness, the economic use of words was an art, succinctness, very much respected. The First Amendment, 45 words long, covers a broad swath of what we Americans consider to be some of our most important constitutionally protected rights. The First Amendment states, Congress, the federal government, remember, shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble to petition the government for redress of grievances. In 45 words, the First Amendment gives every American essentially the freedom to practice any religion they want, but at the same time not be compelled to practice any state-created or apparently state-sponsored religion. Freedom of religion, freedom from religion. Freedom of speech has over time been expanded to not only cover the spoken word, spoken speech, that makes any sense, but to also expand into expression. Things like political donations, giving to candidates of one's choice is considered to be a constitutionally protected right. One's freedom of expression, and I guess at a time when the Supreme Court was a much more lively group, nude dancing was considered to be expression, and limits were placed on the ability of municipalities to completely zone these types of establishments out of business. There had to be districts where these types of businesses could exist, so all of these medical students dancing their way through medical school could earn a livelihood to do so. Freedom of the press, of course, is one of America's most cherished constitutional rights, one in which, in 1964, in a case called New York Times versus Sullivan, the Supreme Court distinguished between libelous statements that were defamatory, either in writing or spoken, against individuals who were quote-unquote public figures, and those who instead were private citizens. In the very critical rule coming out of New York Times versus Sullivan, the court said that public figures who thrust themselves into the public eye, people holding elective office, celebrities, attention seekers, have a higher standard they have to meet in order to be able to collect damages for defamatory statements made against them than average citizens who do not thrust themselves into the public eye. The court reasoned they should have to meet a lower standard in order to prove whether or not this statement was indeed defamatory. The right to assemble and address and seek redress of grievances has created, of course, in the United States, the ability of citizens to protest, to gather on state capitol grounds, maybe, of course, socially distanced, and clamor for the government in question to do things that those advocating these reasons want to do. The Supreme Court has held that this right is a universal right, and unless the group in question threatens to engage in actions that are going to prove dangerous to those gathered around them, they must be permitted to assemble and articulate their speech, even if the speech is hateful, even if the speech advocates causes as noxious as those promoted by neo-Nazis and modern-day members of the Ku Klux Klan. This right to assemble is, again, a broad one. Now, as we travel down the Bill of Rights, we recognize that the Second Amendment, as we've talked about before, laid on the pages of the Constitution as one of the most unaddressed, unlitigated parts of the Constitution until very late into the 20th century, into the 1980s and the 1990s. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. The fact of the matter was that for most of America's history, if there was any impulse anywhere in the country to regulate how many firearms, what type of firearms an individual might own, how they might carry them, how they might brandish them, those decisions were made, if they were made, at the state level, and in many cases, even lower subdivisions of states at the city or county level. Only in the last 40 years or so have we seen the federal government begin to exert more of a voice in regulating this right to bear arms, and thus only in the last 40 years have we seen more litigation in federal courts, and only recently, in the last dozen years or so, has the United States Supreme Court spoken out with some certainty as to what exactly the Second Amendment provides to each citizen, and more recently identified that right as a fundamental constitutional right. More about those in a bit. The Third Amendment is a very good example of how things that were very relevant, that were of great concern to the framers at the Constitutional Convention, one in fact that was plucked almost verbatim from one of the grievances in the Declaration of Independence, has become, at least as we stand here today, an anachronism, a constitutional anachronism, but very instructive as to how these grievances were addressed in the Bill of Rights as the most important concerns of colonial residents at the time. The Third Amendment states, "No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." I don't think we're worried about that this much these days. Check with us in a couple of years and maybe that will be a different scenario. The Fourth Amendment. The Fourth Amendment deals again with this question of searches and seizures. What is the standard that initially the federal police, federal law enforcement, had to meet in order to intrude into a person's home or intrude into a person's belongings in order to effectuate a search? A search, of course, designed to collect evidence as the basis for some potential criminal charge. And the Fourth Amendment very beautifully lays out a process that in 1961 was recognized to be the standard that was going to apply not just to actions by federal law enforcement agencies, but by state and local ones as well. The Fourth Amendment states, as a beginning proposition, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. What a mouthful. And again, break it down. Number one, as a general proposition, any search of a person's home, papers, and effects can only begin by the production of a warrant presented to the individual who is going to be the subject of the search. The warrant must be signed by a neutral magistrate, typically a judge, only if the judge finds that the supporting evidence, an affidavit, usually written and drafted under oath, notarized by a law enforcement officer, stating probable cause, why that law enforcement officer believes the things that they're trying to find, which must be stated with particularity, are in the location the police want to search. So the judge reads this affidavit, sworn, signed by a law enforcement officer under penalty of perjury, and if the judge believes that that affidavit provides to him probable cause, he will sign the warrant, giving law enforcement the ability to then initiate that search and, of course, implicitly seize those things stated in the warrant if, in fact, they are found. So, over the years, courts have been at times very scrupulous in making sure, for instance, that the address on the warrant is properly written and properly stated. Number two, courts have often limited the scope of a search. If you're going into a house, for instance, and looking for stolen refrigerators, it might not be appropriate to look into drawers and under beds and other parts of homes where stolen refrigerators cannot be kept. The scope of the search is important as well. Over time, courts have recognized exceptions, broad exceptions to this search warrant requirement. One of the most notable ones, of course, is the search incident to a lawful arrest, where an individual being taken into custody can be searched to reveal the possession of weapons or other deadly devices from this person being taken into custody. Plain view, another exception to the search warrant requirement. The police pull a car over, they approach the driver to get his driver's license, and while peering into the car, they see in plain view the butt of a gun extending from under the seat. They see drugs or drug paraphernalia. That contraband can be seized without a warrant and be the subject of arresting that individual. Other notable warrant exceptions have evolved over time. But again, a great protection. Many consider this one of the most fundamental protections of the Constitution, keeping the prying eyes of law enforcement out of your home and out of your stuff and out of the trunk of your car unless they can show probable cause, not a mere suspicion or a hunch, but probable cause that you are, in fact, in possession of those items. The Fifth Amendment, taking the Fifth, is, of course, something that primarily relates to the manner in which confessions can be extracted from an individual in police custody. The Fifth Amendment also lays out protections against double jeopardy. An individual cannot be twice put in jeopardy, twice put on trial for the same charge. If you're acquitted once, jeopardy attaches, and you cannot be tried for that offense again within the same sovereign entity, a state court or a federal court. The Fifth Amendment again states that nor shall any individual be compelled in any criminal case to be a witness against himself, taking the Fifth. Now, the Sixth Amendment is again this laundry list of rights to individuals accused of crimes. Initially, federal crimes, but beginning in the 1950s and the 1960s, these rights would be extended to individuals facing criminal charges at the state and local level. Extremely critical, given the fact, as we've mentioned before, 98%, 99% of all criminal prosecutions that take place in the United States deal with violations of state and local laws. And only when the guarantees of the Sixth Amendment, and the Fifth Amendment for that matter, were extended to protect against actions from state and local police and prosecutors were these important constitutional guarantees extended to this area where the overwhelming majority of criminal prosecutions occur at this time. 1967, a man by the name of Ernesto Miranda was arrested somewhere in Arizona, suspected of having committed a burglary. He was brought into custody by law enforcement over a long period of time, interrogated, maybe deprived of sleep, maybe administered what law enforcement sometimes calls a little bit of pain therapy, until he signed a confession which was then the basis of his being charged, tried, and convicted of the underlying crime. In the case of Miranda versus Arizona, the United States Supreme Court would extend this protection against compelled incriminating statements being extracted from a suspect to individuals in local police custody. Over time, we would see the United States Supreme Court extend the protections of the Sixth Amendment. I'll read it very quickly because it covers a whole lot of rights. In all criminal prosecutions, the accused shall enjoy the right of a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature of the cause of the accusation, to be confronted with witnesses against him, to have compulsory process of obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The right to counsel in all criminal prosecutions would be extended to anyone initially charged with an offense that could result in his incarceration in a Supreme Court case coming out of Florida in 1963 called Gideon versus Wainwright. A case upon which a very well-written story by Anthony Lewis, a constitutional scholar, a book called Gideon's Trumpet was written that later became a movie with Henry Fonda playing Clarence Earl Gideon. If you have a chance to watch this movie, I recommend it. It is a dissertation of this process of expanding and extending fundamental constitutional rights to citizens of the states. The Seventh Amendment, somewhat anachronistic, sets a $20 threshold for any dispute, civil dispute, to be brought in a federal court, in a United States District Court, somewhat anachronistic. The Eighth Amendment prohibits excessive bail. It creates a right to bail for most criminal offenses and states that cruel and unusual punishments shall not be inflicted upon anyone in custody. Initially, again, of the federal government, the federal authorities. Now it's been extended to that of all the states. Now, the Ninth and 10th Amendments are very important, sometimes overlooked, but they again are intended to assert that certain things created in the Constitution and even certain rights mentioned in the Bill of Rights aren't a finite list. Maybe there are more. The Ninth Amendment states, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Sort of saying, just because we've listed and delineated certain rights here or perhaps elsewhere in the Constitution, that does not mean that there are not other rights, maybe like the right to privacy, which isn't mentioned anywhere in the Constitution or the Bill of Rights, that citizens might assert belong to them in the future. These delineations of rights are only a beginning of what the Constitution states might be other rights as well. Finally, the 10th Amendment. We've heard a lot in the last few weeks. We're speaking here in mid-April of who has the power to do what regarding how different states deal with matters like social distancing, closing schools, shutting down the economy, engaging in testing of individuals, and matters of that type. Is this something within the province of the federal government? Is this a right that absolutely resides within that of the president and the federal government? Or, in the spirit of federalism, are more of these rights within the province of individual state governors to do, in their judgment, maybe in consultation with their legislatures, what they believe are best and proper for their individual citizens at the state level? The 10th Amendment, lest there be any dispute, states the powers not delegated to the United States by the Constitution, the federal government, nor prohibited by the Constitution to the states, are reserved to the states respectively or to the people. When in doubt, if it's not a right specifically given to the federal government, or if the Constitution does not explicitly deny to the states the right to act in some area, the default position is that that power belongs to the state and to state citizens. Now, how did we get to a point where these 10 amendments, certainly regarding all of these fundamental rights, for most of our history, were considered by our federal courts to only apply to actions coming from the federal government, to the point where many of these rights are now enforceable by citizens against state and local governmental violation. The answer has to do with those three constitutional amendments that were ratified by the states at the conclusion of the Civil War. In 1857, 3 years or so before the Civil War began, the United States Supreme Court, in the Dred Scott decision, ruled that African slaves and their descendants, like Dred Scott, were not persons for the purpose of claiming the rights of citizens under the United States Constitution. In Dred Scott's case, he, as a non-person, non-citizen, could not go to a federal court to argue that somehow, by virtue of having been taken by his owner to free states, he somehow had won his freedom. So 4 years of fighting ensues. Anywhere between 600,000 and 800,000 Americans lose their lives. The war ends in April of 1865, the 9th of April to be specific. Robert E. Lee surrenders to Ulysses Grant. 5 days later, April 14th, 1865, Abraham Lincoln is shot while watching a play in Ford's Theater and dies early the next day. What Lincoln believed could have been and might have been a more generous, orderly reconstruction of the country. The 11 states that had called themselves the Confederacy, making their way back to full statehood, suddenly descended into a very acrimonious 11-year period of reconstruction. Each of the former states of the Confederacy were placed into one of 6 military occupation zones, overseen by military commanders, successful popular Union generals from the Civil War, generals like Ulysses Grant and William Sherman and Philip Beauregard and George Meade. And as part of the process of these 11 states winning their way back to full statehood, they were compelled, I think that's not too strong of a word, to ratify these 3 post-Civil War amendments. The 13th Amendment dealt with slavery, because the fact of the matter is that on January 1st of 1863, when Abraham Lincoln issued an executive order, today known as the Emancipation Proclamation, it had the effect of addressing and purportedly emancipating only the slaves in the 11 states that had seceded from the Union. In many respects, this was a tactical, punitive action, maybe seeking to create dissension in the 11 states of the Confederacy if and when their slave populations found out what the president had done in their behalf. But the Emancipation Proclamation did not affect the status of slaves in 4 states that had remained loyal to the Union during the Civil War. The 4 so-called border states of Delaware, Maryland, Kentucky, and Missouri. So the 13th Amendment, ratified in 1865, would forever ban the institution of slavery absolutely everywhere in the United States. The 14th Amendment was a very necessary creation of Congress in order to deal with the fact that following emancipation, following the banning of slavery, the elimination of slavery, there was a population of non-slaves, former slaves, who because of the Dred Scott case were not American citizens. They were not persons, and therefore could not exercise the right of state citizens. So Congress wrestled with the idea of how could they confer citizenship rights as broadly as possible on this multi-million person population of former slaves now in no man's land living in the United States. And the answer appears in the first part of Section 1 of the 14th Amendment, which states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. I suspect by this time 99.9% of the former slave population had indeed been born in the United States. So by virtue of this 14th Amendment being ratified, like a magic wand, citizenship was conferred upon all of them. And yes, this first part of the 14th Amendment, the birthright citizenship part of the 14th Amendment, is the reason why today anyone born to a mother in the United States, irrespective of whether their mother is an American citizen, whether they're in the United States legally, whether they snuck across the border from Canada into Minnesota late last night, if they're born in American soil, they're born an American citizen. How much of an American citizen? An American citizen that 35 years following his or her birth is constitutionally eligible to be elected president of the United States. Now, Section 1 of the 14th Amendment goes on to try to address directly to the states in the Constitution, directing each state to respect the rights available to these newly created citizens of the United States. It goes on, Section 1 of the 14th Amendment, to state, no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. The due process and equal protection clauses of the 14th Amendment would eventually be the basis by which discriminatory laws set up, in some cases, in the former states of the Confederacy, Jim Crow laws, but in fact laws that were discriminatory throughout the country, particularly as it related to schools and housing and work. These two parts of the 14th Amendment would be the means by which Congress in some cases, but definitely the courts, would enforce equality and equality of opportunity and due process rights to citizens across the country. So it is the due process clause of the 14th Amendment that in 1925 the Supreme Court used to begin this process of extending the protections of rights in the Bill of Rights that the court found to be fundamental, extending the protection of those rights against actions not just by the federal government, but by state and local governments as well. The Supreme Court in 1925, in a case called Gitlow versus New York, had to deal with a New York state law that made, during the First World War, speaking out against the war, in particular, discouraging young men to try to evade the draft, a crime. So the court in Gitlow came back to considering what exactly the 14th Amendment meant regarding due process of law. What does that mean? Over the preceding 25 years, in various Supreme Court decisions, the court had suggested that due process of law might include states being able to deny to their citizens fundamental rights. And it was in 1925 in Gitlow where the court first engaged in a process that legally is called incorporation, taking federally protected, constitutionally protected fundamental rights and incorporating them into the definition of due process that states could not deny to their citizens in order to extend the protection of these constitutionally recognized fundamental rights, again, against the actions of state and local government. So all the way from 1925 to now, 95 years later, we've seen courts specifically identify and designate a federal constitutional right to be a fundamental one. And with this delineation of fundamental, all of a sudden, the protections regarding those rights and the ability for someone claiming that a state or local government had violated that right to go into a federal court and ask a federal court judge to prevent these violations of fundamental rights from further occurring. We've seen it take place in the laws of search and seizure, 1961 case Mapp versus Ohio. As we stated earlier, Miranda versus Arizona, all of a sudden state and local governments, local police, district attorneys could not take individuals in their custody and compel them to testify against themselves, to confess, thus creating the rule in Miranda that the police had to advise someone in their custody whom they intended to interrogate with a warning that the Constitution does not require them to do so. All of the rights in the Sixth Amendment, the right to counsel, the right to trial, the right to a speedy trial, the right to cross-examine witnesses, have all come along and been determined by the courts to be fundamental constitutional rights, as have the right to bail, and as have protections against cruel and unusual punishment. In 1972, in a case called Furman versus Georgia, the United States Supreme Court nullified every law in the country where states executed prisoners for capital offenses, finding that this protection against cruel and unusual punishment was a fundamental constitutional right, causing every state to go back to the drawing board and begin to write statutes regarding the execution of capital felons in a way that would comply with the court's rules to make these executions no longer cruel and unusual. And finally, the Second Amendment, lightly addressed through most of our history. There was no significant federal body of law regarding firearms, types of firearms, possessions, and the like. The last 30 or 40 years, certainly since the Gun Control Act, if you can imagine that name, of 1968, when Congress acted, we've seen, of course, the push and the pull, the ultimate issue involving wedge issues, involving the politics of urban versus rural, of West and South versus North and Midwestern, of libertarianism versus the actions of a government in making communities safe. Only then have we seen the Second Amendment become one more highly litigated. In 2008, in the case of Heller versus Washington, D.C., a federal law, a law affecting people living in the District of Columbia, not a state, but a federal district, the Supreme Court ruled, interpreting with specificity what the Second Amendment does and does not create as far as rights, for the very first time held that the Second Amendment gives to every American the right to keep and bear arms in their homes for self-defense. The court went on to state that this right is not a total and absolute right. The court analogized how in the United States, for instance, every citizen has the right to own property, but in certain cases, local and state governments can regulate how that property may be used. So that right was articulated. What the court, in a 5-4 vote, believed the Second Amendment meant was articulated, but it only had this very small application within the District of Columbia, not a state, not a city, a federal district. So 2 years later, in 2010, in a case called McDonald versus Cook County, wherein a citizen of Cook County, Illinois, the greater Chicago area, asserting that a county statute regulating his ability to keep and bear arms for self-defense was violative of his constitutional rights. When this case made its way through the federal system, the question being, of course, should federal courts consider this case? Because prior to this point, the court had not identified that Second Amendment right to keep and bear arms in one's home for self-defense by the magical words, fundamental right. When the McDonald case reached the Supreme Court in 2010, in another 5-4 vote, the United States Supreme Court ruled that that 2-year prior interpretation of the meaning of the Second Amendment had reached the pantheon of fundamental constitutional rights, meaning that going forward throughout the country, individuals asserting that their rights to keep and bear arms, consistent with the Second Amendment, being violated by state or local law can be appealed and can be taken to a federal court for that court's determination. So thank you, as always, for joining us. I hope you've enjoyed this little jaunt we've made through our nation's founding documents. I hope that we realize and appreciate how much was done in a 15-year period of time to create this framework, which over time, of course, as the United States has grown, the rights and the protections and the applicability of these constitutional protections have extended to all Americans, and how, not in a small way, our founding documents would later create a great amount of guidance to people all over the world who were venturing out into the realm of self-government and who themselves were dealing with the weighty issues of how people should be governed, how law should be made, and whether or not citizens of these countries have rights, again, that are so personal that no government should be able to intrude upon them. And they would find, of course, America's founding documents, all three of them, in this little book. Imagine that. So guiding, so instrumental, and so influential. So thank you all again, and we'll see you very soon.